We're going to post this on our website, but I think we'll wait until afterwards to make that determination and see how things go. We'll see what kind of comments Sam makes on it before we decide that for sure. Well, my name is Brian Marshall. I've been an attorney in Idaho for about 10 years. I'm married and have 5 kids, and live just up the street from you folks off the Curtis Road here in Northview. And we come down here to walk the Greenbelt and park our car in your parking lot all the time, so I appreciate that. I graduated from the University of Idaho with my law degree, and always planned to live and practice law in Idaho, and that's kind of been a dream for both my wife and I. She's a nurse at St. Luke's, and is from this area originally as well. I've got to confess, my background growing up, my dad was a Xerox salesman. And so when I walked in, there was all kinds of flashbacks that I enjoyed, seeing the display room with all the copy machines here. The only thing that they don't do anymore is that really pungent ozone smell that you used to get about 10 years ago, where you walk in and knew it was a copy machine room. But I'm glad to be here and appreciate you being here with me. Estate planning, not the most exciting topic sometimes. You're talking about death, and all the benefits that you get from the money that you spend on your attorney don't really come to fruition until after you're gone and can't enjoy them yourself. So you're really engaged in a labor of love for your children, for your relatives, for your spouse when you're doing estate planning. And there's a whole spectrum of tools that we get to use when we do estate planning. You know, with one extreme being trying to avoid taxation with the government and doing all kinds of complicated businesses and trusts and you know, tax planning. And then there's kind of the other end of the spectrum where it's just focused on saying, hey, look, if something happens to both me and my spouse, we want our kids to be taken care of. You know, financially is part of it, but we also need to pick somebody that's going to take care of them if mom and dad aren't around to help with that sort of thing. So we're going to talk a little bit about that, give you a sampling of what there is available in the world of estate planning, and hopefully at the end we'll have some time to answer some questions if you've got them. But I want to point out the answers to 2 really common questions that I get asked all the time. One of them is, do I really need a will? Or how do I know that I need a will? And the other is, can I just use a will off the internet? Because it's a lot less expensive and it seems like it'd probably work for me. If I answer those 2, then I think you'll be light years ahead of most folks. But we're also going to talk, before we get to death, we're going to talk about nearly dead and not dead but incapacitated, because those are some common issues that come up with estate planning as well. So the progression is kind of to talk about what you do if you're in a situation where you're in the hospital, you're in surgery, or you're in a coma, or there's some kind of situations arisen where you can't make decisions for your health care and you want to appoint somebody else to be able to do that for you. And it's best to do that in advance because you can't always plan for when those kind of things are going to happen. And then there's a little sliver of time where some folks get stuck in a position where you're hooked up to a respirator, you're hooked up to IVs to feed and nourish you, and the doctors have all certified that you're going to pass away, but the only reason you're still with us is because we've got you hooked up to all these modern miracles. And at that point, we use what's called a living will to give our family instructions as to what we would like to see happen. And you've got a few options on what you do there. And then once you pass away, of course, that's where we get into wills and trusts and all the things that kind of direct your estate after you're gone. So, if you look at your outline, the first thing we're going to talk about is the disability. And I think I kind of blew through some of this as far as the benefits of estate planning, but the first thing that we're going to talk about is disability. This is the circumstance where you're in a position where you can't direct a couple of different things. One is your finances, and the other is your personal decisions for health care. Okay? And when we do a power of attorney, and that's really the primary tool that drives this kind of scenario, what we're looking to do is appoint somebody who can make those decisions for you, and hopefully we can find somebody that you trust enough to know what your wishes are and will carry them out. That person becomes what we call a fiduciary under the law, which is a person who has a responsibility not to act for themselves, but to act for you, okay? And we're going to talk about fiduciaries in each of these different categories, but in this particular scenario, we've got a power of attorney who's granted the ability to write checks for you, to buy things for you, to pay your bills, to get into your bank accounts, to manage your investments, because if the stock market starts to plummet and you're in the hospital and can't do anything about it, you want somebody to be able to race down to your broker and say, you know, we've got to get out. And they can't do that without some kind of legal authorization from you that says that that's okay for them. Usually it's going to be your spouse if you're married, okay? We would hope that they're on the same page with you, but it can be somebody else. And I love when I can find a couple of people in here to put in as backups. So we've got a power of attorney that says, if something happens to me, then I want my spouse to be able to take care of the finances, write the checks, go to the bank, work things out with whoever. But if my spouse is either unable or unwilling for whatever reason to get in and do that for me, then I've got my brother Mike, you know, or my Uncle Joe, or whoever I think is good with finances and can do this for me and is willing to step in and take over. You can put together as long a list as you want with backups, but in my experience, usually 2 or 3 people is probably the most that we can find, and that's terrific. If you can't find anybody, then at a bare minimum, it's nice to have your spouse in there so that they have the authority to make those decisions. Go back just one slide, Brian. Can you do that? All right. One of the big problems that comes up isn't necessarily just finances, but you know, we've also got health care. And we can do 2 separate powers of attorneys if you've got different people that you want to fill those respective roles. But often what we'll do is just combine them into one so that you've got one document that you can take into the hospital with you and say, hey doctors, this is who's in charge of making decisions on my behalf. Because I don't want to get stuck in a position where they're asking, you know, I'm in a coma, they may or may not need to amputate my arm, but they need to ask somebody's permission before they can move forward with the procedure. I want them to know exactly who to go to and to talk to about that. If I haven't appointed anybody, then the default on all of this that we're going to talk about is that you have to go to court and get a judge to make the decision for you. And they'll try and consider all the factors, whether you have a relative or a spouse or somebody that's in a good position to do that, but really they're taking a guess at some point as to who's going to be best for that. And they're going to appoint somebody to be a guardian over you and make those decisions for you. If they can't find a relative or somebody that is in a good position to take over that role, then they'll appoint a professional guardian. And there's a couple of companies around town that just do this as, you know, for a living. And they'll step in there and they'll say, yeah, take the arm off. You know? And they may not know that your whole life is golfing or whatever, and that this is going to, you know, be worse than death for you. But what we're trying to avoid is a scenario like that by appointing somebody that you know and trust. Okay, go ahead and go to the next slide. We're going to talk about minor children too. There's a couple of different things that come up here in estate planning. One of the main questions that I get asked on a regular basis is, what happens to me or what happens to my kids if me and my spouse both go off in an airplane and crash, or go off a cliff in a car together and both of us disappear at the same time? And the simple answer is it goes to a judge, and the judge has to decide who's going to take care of those kids the rest of their lives. You can appoint a guardian in your will, though, and that's one of the primary things that drives kind of the simple will business for us, is that we want to give you an opportunity to say, if something happens to both me and my spouse, this is who I want to have take care of my kids. Okay. And the one that I think people are most familiar with is the guardianship scenario, where you need somebody to actually physically take care of your children, you know, bring them into their home, raise them, enroll them in school, take care of their basic needs. But under the law, if you haven't picked somebody, the judge will, but you can, it goes a little bit farther than just picking a person yourself. You actually have some control over a couple of different aspects here. One is the guardianship position, which is the actual day-to-day care, but you can parse those responsibilities out into a separate financial guardian.